So, good evening. My name's Shazia Khan, and I will be teaching you the unit of contract law. And the contract law unit has 5 learning outcomes, and we'll be going through each one quite quickly because normally the sessions last an hour for each learning outcome, but we'll go through quite quickly and we'll look
Yeah,
at the
that's fine.
elements of each learning outcome
Mhm.
and what is the aim of the unit. So, the contract law unit is there to really give you an understanding of like the key principles of contract law, such as like the elements of a contract, the different terms of a contract, implied, express terms. We look at the different remedies if a contract is breached as well. And, these kind of elements will help you complete the assignment. The grading structure for the assignment is a pass, merit, and distinction. Now, this that I've got up here for you that you can you see this is the module specification? This just tells you a little bit about what the unit aims are, the level of the unit, and things like, the structure, the assessment guidance. And then it goes into the learning outcomes on what you would get if you wanted to achieve a pass, what you need to complete to achieve a merit and to achieve a distinction for each learning outcome, okay? And then
Yeah.
on the bottom is the indicative content. So you can look at that in your own time because that's all available on Moodle for you, okay?
Sure.
So I'll stop sharing that and I will show you the assignment brief, okay, which is the assignment and how it looks. And the reason I'm going to show you that because it's already available on Moodle for you to have a look at, and then we're going to go through that in more detail towards the end, okay?
Mhm.
So this is actually what the assignment brief looks like, and I'm sure you've got the same one. It's a level 4 contract law, 30 credits assignment. And it's the first one is the sale of paintings, and then it goes in tasks. So that's the task there. The one thing I want to mention is when it comes to doing your assignment, do not change the wording. Whatever the wording's there, keep that wording, okay? The command verbs and stuff. So if that's asking you, distinguish between an offer and invitation to treat, you won't change that. You can't change that. You can have that as a heading for your assignment and then answer it according to that, okay? Which I'll go through more detail with you. And same for everything, the different tasks and things are all there. And this is how it looks, and it's available on Moodle. That's guidance for the assessors, and it gives them what needs to be produced and things. Okay, so that's all in Moodle. Have you got access to Moodle?
Yeah, I do.
Excellent. So the the unit specification and the assignment brief are all available on Moodle. And when it comes to the number of sessions, you have 5 learning outcomes, okay? And then the assignment discussion. So that's 6 altogether, 6 sessions, okay? If there's any videos on here that you could look at in your own time, okay? So we won't be watching anything. You'll have to look at all that in your own time, okay? So
Mhm.
firstly, I'll start with the first learning outcome and we'll go through that. So just give me a minute. So this is learning outcome 1. The first learning outcome is to understand the principles of formation of agreements. So it's looking at basically how a contract is formed, the different terms of a contract. It looks at the validity of a contract and ways that a contract can come to an end. So that's the whole point of the unit that we'll be looking at. So when we look at the difference between public law and private law, the difference is that public law actually governs the relationship between the state and its citizens, while private law governs the relationship between individuals and private entities. So it could be organizations that are privately things that, for example, private organization could deal with things like contract law, tort law. It could be resolving disputes. It could be anything to do with property, personal injury. That could be private or civil law.
Mhm.
Whereas public law would be like administration, criminal law, because it's against the state. And then when we're looking at elements of that, we're looking at it from the Constitution of UK, how it would apply, okay?
Right. Okay.
So key terminology. What is a contract? When we talk about a contract, what's the first thing that comes to mind for you, Lisa? What is a contract?
An agreement
Agreement, excellent. Between who?
between two persons or more.
Yeah. And could it be oral or could it be in writing? Could it be both?
It could be both.
So it could be orally or it could
Yes,
be
it
in
could be
writing.
orally or written. Yes.
Yes. So it could be an element of how a contract is formed. And
Yes.
then there's 7 elements of a contract, which is in that diagram there as well. So you've got an offer, you've got
Mm-hmm.
acceptance, meeting of the minds, consideration, capacity, legality, and sometimes a written contract. And we have contracts where employment contracts. So if you get a job, Lisa, you
Mm-hmm.
have the expectation that you would get a contract, wouldn't you?
Yes.
If you buy a car and it's on finance, you would get a financial contract, wouldn't you? An agreement.
Yes.
So these things, our contracts are put into place to make sure you are able to understand your, the actual relationship between you and the person making that contract and what you have. Because sometimes in contracts there will be things that you put in place that you can add yourself as a clause. Okay. And
Mm-hmm.
you would add a clause if you, for example, I'll give you an example of a lease agreement. Now, if you've got a lease agreement, in that lease agreement, you could say that I've given you the lease agreement for 5 years. Every year, I want to review the rent. Okay. And that
Mm-hmm.
is a clause that will be put in to say that you want to review the rent every year. And
Mm-hmm.
as a landlord, you are authorized to do that. Okay.
Right.
So that could be a clause that you've put in to make sure that each year you are looking at the rents and increasing it a little bit as well.
Mm-hmm.
Okay. So these are examples. So what is a contract and what does it aim to do? So the whole point of a contract is that it's an agreement, like you said, between the parties and it's legally enforceable. And the whole point of it is to provide a framework for creating and enforcing contracts and making sure, people are accountable. You
Yes.
know, you need to make sure if you have a contract, um, that the person who's gone into the contract with you is accountable for what they've put in that contract. And if one person fails to fulfill their obligations, then they've breached the contract.
Correct.
So do you understand that? If you
Yes,
make
I
a
understand.
if
I
you make a
understand.
contract with me, Lisa, for a
Mm-hmm.
supply of goods or services, and I don't provide that goods and services, then I'm breaching the contract, aren't I?
Yes, you are.
So there's cases around that have happened where opera singers haven't, fulfilled their obligations in a contract and have been liable for breach of contract.
Mm-hmm.
So what is an agreement in law? So an agreement in law is a meeting of two minds. So it's two people getting together and have a mutual understanding of what is what they've decided. So then what their duties are. So it's like a promise, isn't it? But it's enforceable by law, and they are held liable.
Mm-hmm.
This is not a contract, it's an agreement. There's a difference between an agreement and a contract. So an agreement is an arrangement between two parties, whereas a contract is a legally binding contract between the parties. And a
Right.
contract will have terms and conditions, whereas an agreement wouldn't have that, and it's not enforceable in law.
Correct. Okay. Not
So you've got
enforceable.
examples of standard forms, can include unilateral um, agreements and bilateral agreements. So unilateral agreement involves one party making a promise that is accepted by the other party's actions. So that's a unilateral one. Whereas a bilateral contract gives an exchange of promises between two or more parties. So whereas the first one is one party making a promise, The second one is two or more parties exchanging of promises.
Okay.
An example of a unilateral contract could be a reward poster, money for the return of a lost pet. So if someone's lost their cat, the person's offering money if the cat is returned. That is a unilateral contract. Then you've got a bilateral contract, and that could be a contract for the sale of a car, where one party promises to sell the car to the other party, promises to pay the agreed price for the car, and that's a bilateral contract.
Mm-hmm.
Agreement versus contract. And in that diagram, it identifies what the definition, the validity based on, does it need to be in writing, is consideration required, and if it's legally effective. So for an agreement, while all contracts are agreements, not all agreements are contracts. An agreement is a broad term encompassing any understanding or arrangement between two or more parties, while a contract, as we mentioned before, is a specific type of agreement which is legally binding and enforceable in the court of law. And within an agreement, it's not necessarily legally binding. So, whereas a contract is unenforceable in law. So, there's a big difference between that. So, for example, a casual agreement between you and me, Lisa,
Mm-hmm.
could be that, we plan to go out for dinner,
Yeah.
and that's an agreement between friends. Whereas an example of a contract could be, again, a lease agreement to purchase a car. And
Mm-hmm.
that's a contractual agreement that is legally binding and enforceable in a court of law. And that table there looks at unilateral and bilateral contracts as well. So here is a table which looks at the elements of a contract. So offer, agreement, acceptance, consideration, ITT, and terms of a contract. And then the other one looks at the same agreement, acceptance, definition of an offer, whether it's an invitation to treat or an offer, which we will be looking at later on, commercial agreements and types of different terms as well. So we look at conditions, warranties, and inanimate terms. So this diagram identifies the element of that. So for the element of contract law, this has developed over years. It's components of a contract law to make sure is formation, how is it formed? Is it a legally binding agreement? Privity of a contract, exactly who our contractual obligations or to the construction, so how it is, what should be included into the contract. Why is it important to, make sure the contract is done properly?
You said why is it important to make sure it's done properly?
Yeah.
Well, I would assume it's important in cases of if there's a breach.
Yes, in case there's a
Yeah.
breach or if there's any sort of conflict or anything, Lisa,
Yeah. Mm-hmm.
and then if there's a conflict, there have to be vitiation factors, whether the contract is void or not.
Yes.
And then
Yes.
you've got discharge of obligations. At what point are they free from contractual obligations? And then remedies as well. The video there you can look at in your own time. Distinguish
Mm-hmm.
between 1.1, distinguish between an offer and invitation to treat. So an offer is a clear proposal to enter into a legal binding contract. Okay, so while an invitation to treat is preliminary step in negotiations, inviting
Mm-hmm.
others to an offer can be accepted to create a contract, but invitation can treat cannot be. So, there are cases like the Carlyle and the smoke ball. Another example they've given here is for an offer is if someone is a seller is presenting a price for a product with the intention of selling it, a job offer with the specific terms, An invitation to treat is displaying goods in a shop window, an advertisement for goods of sale in an auction. So it's not actually saying that we're selling it for a certain price. So there's a big difference between an offer and an invitation to treat.
Right.
So an offer is a promise or proposal made by one party to another party, which is called the offeree, outlining the terms upon which the offerer is willing to enter into a contract. To be considered a valid offer, it must be specific, complete, capable of acceptance, and made with the intention of being bound by the offeree's acceptance. So if you make an offer, the offeree must accept that offer before it becomes a contract. Do you understand?
Mm-hmm.
And there's no room for negotiation there. So a contract begins with an offer. The offer is an expression willingness to on certain terms. It allows the other party to accept the offer, and that's the basis of the agreement. Then consideration and ITT, an intention to create legal invitation to create legal treat will come into place then.
Right.
Invitation to treat is it's not an offer, it's a step that precedes an offer. So it's not literally an offer, but it's negotiations to make an offer.
Right.
Courts have considered whether or not an offer, in cases, courts have considered this, whether it's an offer or whether it's an invitation to treat. Okay, and there's been
Mm-hmm.
certain cases that have been categorized as it being an offer where they thought it was an invitation to treat. So it's really, really important to understand the difference. They've given an example here: goods displayed in a shop window or on a shelf. When a book is placed in a shop window priced at £7.99, the bookshop owner has made an invitation to treat. What is he trying to do? Is he trying to attract people?
Yeah.
Yeah. When
Mm-hmm.
I pick up that,
Attract sales.
yeah. So that's an invitation to treat. He's inviting people, isn't he?
Yes,
So then when I pick that book up and take it to the till, is that an offer to buy that book?
it is.
Yeah. When the person at the till takes my money,
They've accepted the offer.
they've accepted the offer.
Mm-hmm.
Simple as that, using that book, going in, invitation to treat, getting the book, offer, paying for the book is a contract and it's an offer.
Mm-hmm.
That's the easiest way to understand it. An invitation to treat is a display of generally an invitation for someone. And the famous case is the case of Pharmaceutical Society and Boots, where they displayed um, as an invitation to treat rather than an offer. And Fisher and Bell, which was about a knife, how they displayed that, and it was an ITT. Another case is the case of Grant Partridge and Crickington. So have a look at these cases in your own time because you will need these to help you with the assignment, okay?
Mm-hmm.
So elements of a legally binding agreement. So you've got to have acceptance. What does acceptance mean?
Acceptance means that you are okay with what's being offered and you
Yeah.
accept the conditions. Yeah.
And you're accepting all the conditions and everything, aren't you? So you're accepting a conditional acceptance.
Mm-hmm.
Consideration. That is the exchange of the valued exchange between the parties, which can be money, which can be services, which can be goods. So it could be anything in the form of consideration. Intention to create legal relations is where the parties must intend for their agreement to be legally binding, meaning that it can be enforceable at court of law. So,
Mm-hmm.
it's the legally binding it has to be. Capacity to a contract. This is where the parties have the capacity to enter into the contract. So if someone has capacity, what does that mean?
If they have the capacity.
Yeah, so you can't just enter into a contract, Lisa, if you are, just example, you are 18 years old, but you're not of unsound mind, there may be
Right.
some, yeah. Could
Right.
you
If they
enter?
have the mental capacity and understanding of what they're
Yes,
getting into.
yes.
Yeah.
Anyone should have the mental capacity to know what they are signing.
Yes, yes.
If it's a minor, they lack that capacity, don't they? So, there
Yeah.
are conditions that they have to put in place. So, a person under 18 cannot enter into a contract. Person who's in the influence of drugs, intoxicated, cannot understand the contract. A person who has mental capacity, so who don't understand the nature and consequences of the contract at the time they've got a mental impairment, a bankrupt person or a diplomat in a position of privilege. So these kind of people will not be able to enter into contracts because you've got this lack of capacity, mainly the fact that someone has mental health issues. It does
Mhm.
it doesn't mean they can understand everything. um
Right.
Consent to a parties, they must agree to the terms. Both parties must agree to the terms. There must be consent in place and legality of form. There must be a contract in place that is legally and orally available to them. And they have a legally binding contract. So, for example, if they breach it, they can be committing a crime or breaking the law. So it's really, really important you identify that.
Hmm.
So 1.2, identify and explain the legal rules applicable to acceptance of an offer. So in contract law, acceptance of an offer must be clear, must be unqualified, and communicated to the offerer. So it must be communicated to the offerer. Um, and acceptance must be unqualified. Acceptance must be made while the offer is open. So the offerer must actually receive the acceptance to be valid. So acceptance plays a big part in it. A contract can be terminated by performance breach or termination or by performance. Okay, so breach of a contract. The first one is performance, where the parties have carried have done the contract and the parties have agreed, and the very common way to end a contract where one party does not perform their duties, so that's a performance. By breach, so this is where the party can terminate the other party's breached a condition. They've breached a warranty or a condition and the serious consequences of it.
Hmm.
Another way is to by an agreement, when the parties to a contract agree to end the contract. So an example they've given here is a mutual agreement between them. If a garage couldn't get a particular car for a customer and they'd tried all avenues, then both parties agree to end the contract together. The next one is frustration. So this is if the contract's purpose is frustrated due to unforeseen circumstances. So termination might be an option, in this. And an example of the frustration is if there's a fire in the garage and the cars are destroyed through not anyone's fault, the contracts can be terminated. So, there's different ways of breaching and terminating a contract.
Yes.
An offer is made where a person shows a willingness to enter into legal binding contract, whereas an invitation to treat is merely a supply of information to tempt a person into making it. There will be misrepresentations and mistakes which will go through in a contract which make it not legally binding and breached. So a really famous case in regards to that is the case of Harvey and Facey, 1893, which looks at the facts of the case in that slide and also looks at the issue that was identified and the ruling in that case. So have a read of that in your own time as well, please. Um,
Mhm.
Another difference between invitation to treat and an offer is that and like we said, an offer is a clear statement of terms under which the offerer is willing to be bound. They are bound under that. And an offer creates a binding contract upon acceptance by the offerer, whereas invitation to treat is primarily a step in negotiations, not intended to be legally binding, and invites others to make offers which the invitor can then accept or reject. So once an invitation is made, for example, if ITT is an offer made to an individual, can it become a sorry, if ITT can ITT become an offer?
ITT?
Invitation to treat, I'll say, sorry,
Oh, yeah.
yeah.
It,
Can it
it
become
can become an offer.
the example we use for the book? That was where it was an ITT at the start to invite
Yeah.
people in to get the book. Then you pick the book up, that's an offer. And then when you pay for it, that's acceptance there.
It's acceptance, yeah.
So it can. So the main cases relevant to offers and invitation to treat are Carlisle and Carbonic Smoke Ball, really famous case. Fisher and Bell, another really famous case. Pharmaceutical of Great Britain and Boots. These three cases are really, really famous cases in regards to offers and ITT. The facts of Carlisle and Carbolic Smoke Ball are there, where the manufacturers, it was about smoke balls which could prevent influenza, and it was a publication. And then what was identified? Was it an offer or an ITT in this case? So have a read of that case. 1.3, assess the requirements for a valid consideration. So consideration requires a bargain for exchange where each party provides something of value, which can be a promise, an act, or forbearance. The consideration must be sufficient, meaning that it has some legal value, though it doesn't need to be adequate. It must be something that is not pre-existing legal duty and must move at the desire of the promisor. So it could, what makes a contract enforceable? An offer made by a promisor, an acceptance by the promisee, consideration in the form of money or any other value, capacity of both parties that they have sound mind, also legality of terms and conditions, that they've been accepted, the terms and conditions have, meeting these requirements, the consideration then becomes valid and forms a legally binding contract.
Okay, yes.
So, consideration is really important in elements of, try to identify a legally binding contract. For consideration to be legally sufficient value, a party can refrain from exercising a right that its party is entitled to. And consideration, as we said, can be also be bargained for, which actually is that it's given in exchange for something else. That's what it means. In real terms, let's say John and Jamal are now negotiating the sale of a bicycle that was displayed in the auto repair shop. John wants to take up biking, so he offers £50 to Jamal in exchange for the product. Jamal will give the bike to John upon receipt of the cash. So both parties bargain and receive a detriment. John's bank account is reduced by £50, but he's received some new wheels. Jamal no longer has his bike, but has an extra £50. And now the next one is 1M1, which is a merit one. Critique the significance of practical benefit as consideration. So what is practical benefit? So practical benefit in contract law can serve as a valid consideration, meaning a promise to perform an existing contractual obligation. And this can be legally binding if it provides a practical benefit to the other party. So this concept established cases, and they've given the case there, William Roffey case, which acknowledged that even without a strict legal detriment to the promisee, a real world advantage gained by the promisor can be sufficient. The traditional view of consideration was seen in the case of Stilk and Myrick, which required a strict legal benefit to the promisor or legal detriment to the promisee. So you've got factual benefit and you've got practical benefit. So factual or practical benefit can be sufficient in consideration, as we mentioned earlier. And the famous case to deal with that is the famous case of Williams and Roffey. And this identified the element of the factual and practical benefit in consideration. 1D1, which is the distinction, if you want to aim for the distinction one, assess the limitations of William and Roffey 1991 in relation to a promise to accept less. Now, this case, like we said, looked at practical benefit, and that could constitute consider sufficient consideration for a promise to pay more. So this case identified elements of, the element of practical benefit that you can look at in your own time. So it's quite a lot to have a read of the case and what it was decided in that case. So have a look at that in your own time. The facts of the case as well, and what was held in the case, what was the principle that was the judgment Lord Justice Gildwell held, and what his decision was. So have a look at that. And then it looked at how did Williams and Ruffy, the case, change the law. So it looked at altering the law regarding consideration in contract law by introducing the concept of practical benefit. Before, that concept was not in place. After William and Ruffy, that concept, the law introduced that to look at the practical benefit in this side. So when you look at a contract, you've got acceptance, offer, end of specified term, end of reasonable time, failure of precondition, rejection, counter offer, death of the offeree or death of the offeree, and withdrawal. So this is just a quiz that you could use and look at in your own time on Kahoot. And these are the references used for learning outcome one that you could right click and go onto the references to use. Okay, so this is quickly learning outcome one. The next one is what I'm going to look at. Stop sharing that. Is learning outcome two. So we've got to go through all of them so you have a little bit of an idea. Okay.
Okay.
So the next one is learning outcome two, which looks at different concept of identifying elements of. Just 1 minute. So this one looks at understanding the rules that govern the content of a contract. And here we look at what a term is, what representation is, and we look at the several terms, whether they're valid and enforceable. And we look at the elements of a representation and the distinction between a term and a representation. So compare and contrast to 2.1, compare and contrast terms and representation. So in contract, a representation, in contract law, a term is a legally binding part of an agreement creating an obligation for the parties involved. So what is a term? What would a term be in a contract? What could it?
The terms would be what's expected,
So give me,
like the rules to abide by.
yes. So could it be like if one party was to deliver something to another party, they would have the delivery date. Would that be a term?
Yes.
Yeah,
Or,
excellent.
or,
Yeah,
or a completion
yeah.
date.
So then you've got a term that's an obligation, legally binding part of the agreement. Then you have a representation, on the other hand, is a statement made to induce someone to enter into a contract, but is not necessarily part of the contract itself. So, an example of that is a seller stating that the car's never been in an accident, or a job applicant claiming a specific skill set, which is not true, but they influence the decision.
Mm-hmm.
So misrepresentation is another part, another element of it. When we look at misrepresentation, we look at the different types of misrepresentation. What do you think misrepresentation is?
Misrepresentation, I'd say, like if you said something to get the buyer and then it turned out to be false.
Yeah, it's a where you are giving a false statement for someone to enter into the contract. And there are different types of misrepresentation. We'll go through innocent, negligent, and fraudulent. And these types of misrepresentation are important when you're trying to get someone to enter into a contract. You will do that because you want to, them to enter into that contract, but it's fraudulent misrepresentation. The sources of terms, so we've got sources of terms. We look at express terms, implied term, which is an implied term is by statute, by courts, and by custom and usage. So terms of a contract set out duties. So each term will set out contractual duties for each party. And we'll look at each term in more detail. So generally the terms of a contract may be either wholly oral, wholly written, or partly oral or partly written as well. Either type of statement can become a term of a contract. So the first one is express term. An express term is a contract that are specific provisions that parties to the agreement have explicitly agreed upon, either verbally or in writing. And these terms are clear, unambiguous, and represent the parties' stated intentions within the contract. The oral statement strength of the term, they differ from implied terms, which are explicitly stated but are understood to be part of the agreement based on the law, custom, and the nature of the contract. The strength of the statement is that it's more likely to be viewed as a term. Cases, you've got Dick Bentley and Productions Limited and Harold Smith. Oral statements are written contracts and are put in writing, and it's appearing in a written agreement which is agreed by the parties. So it could either be established through spoken conversation or through written documentation, such as a contract, email, or terms of a contract. And it should be signatory to successfully argue. So there must be a signature in place. Oral, as we said, oral incorporation, it could be incorporated orally as well. The case of that is Chapelton and Barry Urban District Council. And generally speaking, it's harder to show incorporation the more onerous or unusual it's written. Express term, in regards to interpretation of express terms, when construing meaning of contractual terms, courts attempt to ascertain the intention of the parties. So the whole point is trying to ascertain why the parties have put in an express term. You know, why was there need to put in an express term? And the courts will look at that in more detail when looking at cases. And the case they looked at was the Investors Compensation Scheme Limited and West Bromwich Building Society 1998. Parole
Mm-hmm.
evidence rule is where a contract is reduced in writing, neither party can submit evidence intrinsic to the contract.
Mm-hmm.
Parole rule exceptions, so you must have proof of custom or trade uses. You must clarify ambiguity, show capacity to the parties, show how the contract operates, and support to be rebutted for implied terms. Express terms are really crucial for defining the core obligations and rights of the parties involved so that they're able to establish the boundaries of that contractual relationship. Collateral contract with an oral statement can be deemed to be binding when it is not a term in a written contract. So if it gives rise to a collateral contract, so if one party say that he will sign the written agreement if he is assured that it is to be construed in a certain way. Good example of device in operation is the City and Westminster Properties Limited and Mud case. So entire agreement clauses. So a breach of an express term can give rise to legal action, such as claim for damages or specific performance. So these whole point of these clauses is to aimed at preventing one party claiming an earlier statement is also part of a written agreement. Implied terms, we have four categories that they fall in: implied by fact, implied by law, implied by custom, and implied by trade uses. So the first one is implied by fact, and this is where the terms are specific to a particular contract and are implied based on the presumed intention of the parties to make the contract workable. So a court might imply a term if it's so obvious it would have been included had the parties thought about it, or if it's necessary to give business efficiency to the contract. The next one is terms implied by fact, which are in regards to it, where terms are subjective in the sense that ask what parties in the case at hand would have agreed. So, what a reasonable person would have agreed in that time. And the case in regards to that is Spring and National Amalgamated Stevedores and Dockers Society 1956. Implied by law. So this again is these are terms that are automatically included in certain types of contracts due to the nature of the agreement. So, for example, the Sale of Goods Act 1979 implied terms are the quality and fitness of goods into a contract for the sale of goods. So these are implied by law and put in there by the law. Terms implied by custom, which are and by usage, terms implied by based on the established practices, and for example, a particular way of doing something. So it's evidence that it's local custom that it's implied by, and it's implied in a certain way that it's been used historically. 2.2, identify the sources um, of contractual terms. So we've said we've got terms maybe expressed or implied, and then we've got a case, really important case in regards to that, the case of Scammell and Houston 1941. And in this case, an agreement provided for the balance of the price to be paid on hire purchase terms over a period of 2 years. And it was held that the words hire purchase terms were considered too imprecise as the seller had a range of such items. So express and implied terms, as we said, are needed in regards to agreeing upon something when it comes to parties, both orally or in writing.
Right.
Are you okay so far, Lisa? Yeah?
I'm good. Yeah, I'm fine.
Excellent. Ask away if you need any, if you don't understand anything, okay? Contractual
Yeah, sure.
terms in English law, which terms are incorporated in the who is it up to identify which terms are incorporated into the contract? Is it up to
Who
the
is it?
parties?
Yeah, I'd say it's
Yeah.
up to the parties.
Yeah, so if you're making a contract with me, it's up to us too, isn't it? To identify what we want to put in the terms of the contract. Whether
Yes.
the terms are implied or expressed, that's up to us to identify that.
Yeah, and the terms must be acceptable by both parties.
By both parties, yeah. The famous case in regard to types of terms, which are conditions, which we're going to look at in a little bit more details, conditions, warranties, inanimate terms, and these are the Moorcock 1889 case, which was really important in regards to identifying between conditions, warranties, and inanimate terms. So 2.3, distinguish between conditions, warranties, and inanimate terms. And we're going to look at the first one, which is a condition. And the condition are essential in terms of a contract going to the root of the contract. The breach is considered a serious matter. So a breach of a condition allows the innocent party to terminate the contract. So this is the most severe one, and claim damages for any losses incurred. In a contract for the sale of goods, an example would be for a condition. A condition might be the delivery of a goods of a specific quality. If the goods are of a significantly lower quality, the buyer can terminate the contract and seek a refund.
Hmm.
A warranty is the next one, which is of lesser importance than a condition. So warranties are subsidiary terms of a contract, which are less crucial than conditions. A breach of a warranty only entitles the innocent party to claim damages, but not to terminate the contract. For example, in a contract for the sale of a car, a warranty may be a promise that the engine is in good working order. If the engine develops a fault, the buyer can claim damages to cover the cost of repair, but they cannot reject the car. Breach of a warranty is in the case of Bettany and Guy, 1876. Then we've got inanimate terms, which can be either conditions or warranties. They can be both. And
Hmm.
this was established in a really famous case, um, which is the case of Hong Kong Fire Shipping Company and Kawasaki 1962, which looked at conditions and warranties. But the inanimate term approach looks at the effect of the breach and whether the innocent party to the breach was deprived of substantially the whole benefit of the contract. Here, only where the innocent party was substantially deprived of the whole benefit will they be able to treat the contract as an end. So the most important one out of them is the conditions. Okay.
Mhm.
And the other famous case is the Hansard Node case, 1976, looked at conditions and warranties as well. 2D1, analyze the court's approach to interpretation and validity of exemption clause. So the courts have a different approach in regards to exemption clauses. The courts employ a multifaceted approach to interpreting and assessing the validity of exceptional clauses. What they say is the courts will generally interpret exemption clauses strictly, especially against the party relying on them, and will scrutinize clauses that seek to exclude liability for breach of contract or negligence. So they do look at them in quite more detail, and then an exclusion clause can be incorporated into a contract by a signature, notice, or previous dealings.
Mhm.
So a signature in regards to exclusion clauses, exclusion clause limits or excludes a party's liability under a contract. And like we said, it could be done in three ways. So the incorporation of a signature, so this is when a contract is signed by all parties. Any exclusion clauses included within the contract are typically incorporated into that contract, and that's literally signing it. And that's the case of Liestrage and Grobel, which looked at the clause of signature in regards to that. Then you have a
Right.
notice. So an incorporation of a notice. Um, so this is where if a contract is not signed or if the clause is in a separate document, the party relying on the exclusion clause must take reasonable steps to bring it to the other party's attention
Mhm.
before or at the time the contract is formed. And this could involve providing a copy of the terms, displaying a notice, or drawing specific attention to the clause. And the case in regards to that is the case of Thompson and LMS Railway 1930 and Ollie and Marlborough Court 1949. And then previous dealings. So for exclusion clause to be incorporated by previous dealings, there must be a consistent cause of dealings between the parties. So there must have been a history of dealing with them previously, and it's deemed incorporated into that contract. Case of Sperling and Bradshaw, 1956. The next one is the wording must cover the loss. So, to have an effective legal document, the courts interpret the wording words narrowly against the interests of the person seeking to rely on the clause. So, there must be clarity, it must be clear and unambiguous. It must be, the wording must leave no room for interpretation. And the case of that is the Photo Productions Limited and Security Code 1980. Statutory rules. So even if a clause passes the common law test, it must satisfy the statutory rules. And they are contained in the Unfair Contract Terms Act and the Unfair Treatment of, the Unfair Contract Terms Act in regards to that. So they will look at the capacity of that, but they will also look at the element of where there's a standard form of contract between a business and a consumer, or any attempt by a business to exclude or restrict any sort of breaches. The burden of proof is on the individual to rely on the clause and to make sure that it's unfair and unreasonable.
Mhm.
And the case in regards to that, in regards to statutory rules, is the case of St Albans City and District Council against International Computers Limited, 1994. So the unfair terms in consumer contract regulations applies to contracts where the seller is acting in the course of business or whether the other party is a consumer, or the terms have not been individually negotiated. So it's really important that the term is unfair if it's not expressed. It needs to be in um in language they can understand. Why do you think it's so important that the wording of it must be, specific for the person to understand it?
So that nothing is misconstrued and everybody understands exactly
Yeah,
what
so
the
it's not
terms are.
unfair that it
Yes,
allows everyone to understand it, and that there's nothing misconstrued out of it. Because
yes,
sometimes wording, the jargon is not understood by everybody. So,
it's
it's
true.
important that the courts use language that people are able to understand. Because it's the
Hmm.
normal, reasonable person, and if they're not able to understand it, then it's difficult, isn't it, in that term?
Yes, it is.
So this is learning outcome two. So we've done learning outcome one, we've done learning outcome two. Now we're on learning outcome three. So let's see if you can you see my learning? Let me share it again. Learning outcome three. So learning outcome three, it looks at elements of understanding the vitiate, I can never say that, vitiate elements that may affect the validity of contract. So here we look at elements of identifying 3.1, identifying the um, elements of actionable misrepresentation. So
Hmm.
we look at misrepresentation, which we mentioned earlier, is a false statement. It's a false statement which impairs the validity of a contract. So, there's misrepresentations, there's other forms as well, which we'll go in more detail, but misrepresentation is a false statement of fact, which is trying to induce the other party to enter into the contract. So it's, trying to get the other party to enter falsely into that contract, and it's a false statement of fact made by one party to another party. So trying to enter into that contract.
Yes.
A misrepresentation may be fraudulent, negligent, or innocent, which we'll go through. There's three main types of it, and they occur in different ways. And when you have a fraudulent misrepresentation, a false statement is made knowingly without belief in its truth or recklessness. So we'll go through is the negligent is made by a person who has no reasonable grounds to believe that it was true, and innocent is wholly belief that it was true.
Hmm.
So 3.2, differentiate between fraudulent, negligent, and innocent misrepresentation. So fraudulent misrepresentation is the first one. So fraudulent misrepresentation is involves intentional deception.
Right.
So that's intentional deception. What do you think that means?
It means that you knew from the onset that you were lying to the person just to get them to, probably scam them to get money.
Excellent. Yeah, you knowingly knew, didn't you? You
Yes.
knew everything. And fraudulent
Yes.
misrepresentation is the most serious type, involving a false statement made knowingly with its belief that it's truth or recklessness. The
Hmm.
key element to intent is to deceive or mislead that other party.
Yes.
And the most famous case of fraudulent misrepresentation was identified in the case of Derry and Peake, 1889. And another example is Thomas Witter case and the Flanagan case that you could have a look at
Hmm.
in your own time, okay? Then we've got
Yes.
negligent misrepresentation. This is a false statement made carelessly or without reasonable grounds for believing it to be true. There's no intent to deceive, but the party making the statement failed to exercise reasonable care to ensure its accuracy. So this is really to do with carelessness, disregard for accuracy. And
Right.
the famous case in regards to that is the case of Caparo Industries and Dickman 1992, which looked at the test of duty of care.
Right.
Alternative approach in regards to um, negligent misrepresentation was pursued in the Misrepresentation Act 1967, Section 2, Subsection 1, which allows for such a claim and contains the key components. The last one is innocent misrepresentation, and this is a false statement made in the honest but mistaken belief that it is true. So here, there's no intention to deceive or negligence in making the statement. So this is an honest mistake, really. It's not something that would be, someone's done intentionally.
Right.
So next one is looking at elements of 3.3, analyze the development of the doctrine of duress. In regards to it, the doctrine of duress was developed from a narrow concept of physical coercion to, bring in someone to, make something that's not genuine, try to get the person to, duress could be threats or violence. It could be any elements of that, someone who's duressed, someone maybe uh, threatening you, to enter into a contract.
Yes.
There's a lot of threat that goes on and undue influence that happens due to elements of, people trying to enter into contract. And
Mm-hmm.
these duress and undue influence are legal doctrines that can invalidate the contract. Duress, as we said, involves coercion. So it could be like someone threatening another person, while undue
Mm-hmm.
influence involves exploitation of a relationship of trust. So give me an example of undue influence. So it's saying the exploitation of power. Undue influence.
Um,
It's a power trip, isn't it? Someone who has power
yeah.
over the other person.
Mm-hmm.
Could
Like
it be?
threatening to harm them if they don't sign something,
Yes,
like
yes,
sign over their house to them or sign,
yes, yeah. That could be, I'll give you a good example of that, is a doctor taking advantage of a patient's vulnerability to sign a
yeah.
contract could be considered undue influence. There may be cases out there, Lisa, like that, where
Yeah.
doctors have, done that because, maybe the patient is an elderly patient who suffers from dementia. It
Mm-hmm.
doesn't have to be a doctor, it could be someone else, that is undue influence.
Yes.
So duress to the person is refers to a situation where a person enters into a contract because they're forced or coerced by threats of violence or harm to themselves or others. Here, the coercion is undermines the concept of free consent. And the famous case is the case of Barton and Armstrong, an Australian case that established that duress to the person could be a factor in a contract, even if it wasn't the sole reason for entering the contract. So, that's where a person is threatened. Then you have duress to goods. Duress to goods is when someone enters a contract because their goods are being threatened and unlawful destruction, damage, or detention. So this
Mm-hmm.
form of duress can render a contract voidable, meaning the coerced party can choose to cancel it. And this could be an example of this could be a business owner refusing to release another's goods unless they agree to a new contract, or it could be
Mm-hmm.
a person paying a ransom to recover their unlawfully detained goods. And these are the case of Skeet and Beale, 1840, and Maskell and Horn in 1915. And then we've got economic duress. Let me just get slides. So economic duress in contract law occurs when one party coerces another party into a contract by exerting illegitimate pressure, leaving the coerced party with no reasonable alternative but to agree. This illegitimate pressure can include threats to breach a contract or engage in other unlawful actions. If economic duress is proven, the resulting contract is voidable, meaning the coerced party can choose to set it aside. And that could be things in the case of the Occidental Worldwide Investment Corporation. It could be a supplier threatening to breach a contract unless the buyer agrees to a price increase, so it could be elements of that economic duress.
Mm-hmm. Right.
The Privy Council identified 4 factors to consider when you look at economic duress. Did the person claiming to be coerced protest? Did the person have any available course of action? Were they independently advised? And after entering the contract, did they take steps to avoid it? So these are some of the things that need to be identified. Illegitimacy of the pressure. Um, if so, in contract law, a contract can be deemed invalid if it was entered under illegitimate pressure, also known as duress. What is illegitimate? What can illegitimate pressure be? Could it be again the element of threatening as well?
I'd say yes.
Yeah, it could be. It occurs where one party coerces the other party into an
To do
agreement through
something they don't want to
unlawful
do.
or
Yeah.
morally reprehensive means. So it could be the use of unlawful or morally reprehensive means to compel someone into signing the contract. And that could
Mhm.
be the case. That's in the case of CTN, Cash and Carry and Gallagher, and General for England and Wales 2003, are an attorney. The effect of finding duress. So a finding of duress in contract law generally renders the contract voidable. So if you find it, the contract will be voidable, not void, meaning that the
Right.
party subjected to duress can choose to rescind the contract, which means cancel it, or the contract or affirm it. If the contract is rescinded, which means cancel it, the contract is treated as it will never exist, and any benefits exchanged under it may be subject to restitution. Additionally, if the party under duress may be entitled to damages, to compensation for losses caused by that duress.
Right.
So 3M1, and that is the merit one. Examine the remedies available for fraudulent, negligent, and innocent misrepresentation. So you've got rescission, which is one of the elements of it. Is a remedy where the remedy is available, damages instead of rescission, although the court will usually prefer to make an order for rescission. And then you've got affirmation, which is where, despite the misrepresentation, the representee had held themselves out to be happy, where the contract is therefore affirming the misrepresentation. Lapse of time. So if there's a lapse of times, the courts there's a different approach the courts will take, because each individual case has its own merits and they will consider it through that.
Right. Okay.
Restitutio integram, which actually is a Latin meaning, meanings restoration to the original condition. In legal
Mhm.
context, it refers to the act of undoing a transaction or situation and returning all parties to their pre-existing condition. So just, returning them back.
Right.
And it's often a remedy that's used where contract is cancelled due to misrepresentation, mistake, or other factors. Cases in regard to that is Clark and Dixon and TSB Bank PLC and Camfield 1995. Third party interest. So this is refers to the rights of third party interest where individuals have the rights of a third party. Remedies are unavailable. And the case in regards to that is the Crystal Palace Football Club, and damages differ for each type of case. As we mentioned, everyone has a different case. Fraudulent misrepresentation requires a high standard of proof, and they have to, look at the test of reasonable foreseeability, where the loss will only be claimable if the statement maker has reasonably foreseen that the fraudulent statement would have resulted in such a loss. Negligent misrepresentation is the case of um, Headley and Brine. Unlike damages for fraudulent misrepresentation, the damages are limited for negligent misrepresentation. Uh, Negligent misrepresentation in the Misrepresentation Act. Under Section 2.1 of Misrepresentation Act, damages are awarded based on the fraudulent misrepresentation. And also they will look at the severity of the case, whether the damages are available, and they will look at the relationship between rescission and damages. The next one is 3M2, which is a merit one, contrasts the effects of misrepresentation and mistake on a contract. So misrepresentation and mistake both impact on the validity of a contract, but they differ in their nature. Misrepresentation involves a false statement inducing a contract, making it voidable at the misled party's option, who can then choose to rescind it, which is to cancel it. Whereas mistake, on the other hand, relates to a shared or unilateral misunderstanding about a fundamental aspect of the contract, potentially rendering it void from the start. So as mentioned, three types of misrepresentation: innocent, negligent, and fraudulent, which we looked at earlier. And the
Mm-hmm.
effect of misrepresentation is that the contract is voidable. And the remedy depends on the type of misrepresentation, whether damages are awarded or not.
Right.
A rescission contract law remedy bars misrepresentation, mistake, and fraud. So rescission is a remedy made available when the underlying basis for a contract is fundamentally tainted. Some conduct on behalf of a contract party undermines the very reason that the other party made the contract in the first place. The contract can be rescinded at the option of the affected party. Rescission is an equitable remedy which allows a contractual party to cancel the contract. Parties may rescind it if they are victims of factors such as misrepresentation, mistake, duress, or undue influence. Rescission is the unwinding of a transaction. Indemnities where the court order payment for expenses incurred in complying with the terms of the contract. And damages is the remedies varies according to the type of misrepresentation. And as I've mentioned before, the type of case as well, because each
Yeah.
case is different. So looking at mistake in contract law, mistake occurs when one party holds an erroneous belief about a vital aspect of the contract at the time of its formation. These mistakes can render a contract void or voidable, depending on the type of mistake and its impact. So there's four types of mistake. We have common mistake, mutual mistake, and unilateral mistake, and mistake as to identity. So common mistake is where both parties share the same mistaken belief about a fundamental fact. For example, both parties mistakenly believe a specific item exists, but it has been destroyed. Then you've got the next one, which is a mutual mistake. And this is where parties misunderstood each other's intentions, leading to different interpretations of the contract terms. For instance, one party intends to sell one item while the other intends to buy a different item. And then you
Right.
have unilateral mistake, which is where one party is mistaken about a fundamental fact and the other party is either aware of the mistake or should have been. An example is when one party knows the other party is mistaken about the quantity of goods being purchased. And then mistake as to identity is where a mistake as to the identity of the contract is made, where the contract will be deemed void if the identity of the person is central to the conduct.
Mm-hmm.
So these are some of the references used for learning outcome 3. So we've gone through learning outcome 1, 2, and 3, and the next learning outcome is learning outcome 4. Can you see this? It says, can you see that, or just share it again? I think I might have to share it again. Let's.
I can see it.
Oh, you
Mm-hmm.
can see. Can you see? Oops, I don't know. Can you? Oh God, I don't know what I've done now. Let me just share it again. Sorry about that. So
Mm-hmm.
this is learning outcome 4. Okay, and in learning outcome 4, we look at understanding how a contract can be discharged.
Mm-hmm.
So let's go to that. Oops, think of. So when we look at understanding how a contract can be just discharged, we look at, let's just look at what a contract is. So a contract is a legal binding agreement promised by one party to fulfill another obligation, and a valid contract, what it is, and then we have elements of it. offer, acceptance, agreement, and consideration. So we look at 4.1 and it looks at explain the different ways in a contract can be discharged. So you have the first one is by performance. Just 1 minute. Oh God, what have I done now? So for performance, this is when all parties to a contract have fully and completely performed their obligations as specified in the contract. The contract is then discharged. By agreement, this is where parties can mutually agree to terminate their contractual obligations. By a breach of contract, and this is where the innocent party has the right to terminate the contract, and by the law of frustration as well. So
Mm-hmm.
termination of performance is where they've completed the contract and it's by both parties, they have fully completed their obligations and the contract is discharged. Then you've got termination by agreement. So this is where parties have mutually agreed to terminate the contractual obligations, and this is achieved through a novation, a rescission, which is cancelling the contract, or accord satisfaction in regards to agreeing to accept something different than what was originally agreed. And this is where both parties consent to it, okay?
Right.
Legally binding variation for termination. This is for the agreement to be legally binding. There must be fresh consideration from both parties, a deed releasing the other party from their obligations, or a separate agreement supported by fresh consideration, or promissory estoppel applies of the fact. Then we've got conditions subsequent. So these terms of contract can be built into a contract to terminate it. These are known as conditions subsequent. And condition subsequent stipulates a state of affairs which causes existing contractual obligations to come to an end. Termination of breach of contract. If one party fails to fulfill their contractual obligations, this is a breach of contract, and the other party may have the right to discharge the contract, and the innocent party can choose to terminate the contract and potentially get damage and repudiate the breach. Is the breach serious enough? So if it depends on the type of terms and conditions and whether there is a serious breach for it to be, serious enough for them to deal with it. Anticipatory breach. This occurs where one party indicates either through words or actions that they will not fulfill their contractual obligations before the performance date. And this allows the other party to treat this as a breach and take action, such as terminating the contract or seeking damages.
Mm-hmm.
When there is a repudiatory breach, so repudiatory breach of contract occurs when one party's actions demonstrate clear intention to no longer be bound by the contract, or when the breach is so serious that it deprives the other party of the substantial benefit of the agreement. This breach gives the innocent party the right to terminate the contract and claim damages.
Can I ask a question about that?
Yeah,
Okay, so I'm personally dealing with a scenario where I would have paid for services to be done last year.
yeah,
They weren't done. I signed a contract. This was for some cosmetic surgery, I'm just
yeah,
being honest with you.
yeah,
But I later decided, based on like reviews and things that were
yeah,
happening with the clinic, that I no longer wanted to proceed. And
yeah,
then things that they promised, I realized, okay, well, in the contract, they're saying, oh, you're going to get these 10 free massages. And then as time go by, I'm not being able to get this stuff. And then I'm also anemic. So they wanted me to buy like to buy bags of blood, and all these things
yeah, yeah,
weren't mentioned to me prior. Even though I said even though I let them know that I have low iron, they were like, oh, that's no problem. We can do the surgery, no problem, no problem. Anyway, so no surgery was done. Mind you, this contract was signed last June.
yeah,
And past months, I've been sending requests to them to refund me, and they keep denying it. But in the contract states that I can request a refund for any reason, and I would be given my money back minus the deposit. I
Yes,
had no
yeah,
issues with that.
yeah,
And that's what they have in their contract. But every time this is like the eighth time I've requested a refund and they're denying it. So the last time, a couple of weeks ago, they're saying they couldn't give me a refund because I can reschedule a surgery. I said, I don't want to reschedule a surgery. I just want my money back. As per your
yeah,
contract,
yeah,
I'm entitled to my money back.
yeah,
And they keep denying it. Then they said, oh, I have a surgery scheduled in 30 days. I said, please provide me proof where I have a surgery scheduled in 30 days. Because they're
yeah,
saying, if you have a surgery scheduled within this time, you're not entitled to a contract. Sorry, you're not entitled to a refund. But I
yeah,
have no surgery schedule. This has been over a
yeah.
year. There's no
But
surgery schedule for this.
have you contacted their like awarding body? Do they have a body that they deal with?
Yeah. I've been speaking to their refunds department, and that's all they keep telling me, that I'm not entitled to a refund, even
No,
though the
but
contract
they
says
didn't like they refused, they didn't perform the obligations.
no.
No, so you need to be telling them that you have the right because the contract has been breached. You've discharged the contract, but you were an innocent party and you
Mhm.
had other illnesses. That's why you can't perform the contract.
Yes.
And they failed to provide you that. You wanted to terminate the contract,
Yes.
and you need to you know is it like a medical institution?
Yes, it's a medical clinic that does
But
cosmetic
are they do
surgery.
they are they like are they under a body of people, like a professional body?
Well, they should be under a professional body. Yes.
Yeah,
Yeah,
that's
yeah,
who
they
you
have
need
to
to
be.
write to, Lisa.
Mm-hmm.
That's who you need to write to, and you need to make sure that you write a strong letter to support everything, put everything in, and say that the law in regards to it identifies that you've not performed your obligations, but also that you've terminated the you don't want the contract to go ahead due to your illnesses and things like that. You need to be quite strong with the letter.
Mm-hmm.
You need to write to the professional body, not to and what you need to do is you need to write to the clinic to tell them that you're going to the professional body
Yes.
because they'll
Yes.
get scared. They will really get scared.
Mm-hmm.
If you find out who their professional body is and say that you're going to go to them and you're going to you're going to say that this is the law that says that you should have provided me a good service, or you should have done this, I can discharge my contract. You need to identify that in there.
Yeah.
But do a proper letter to them first to tell them that they've been dealing with this situation. It's not being dealt with. I have no alternative but to, go to the professional body.
Yes.
And
Yeah. I'll have to
that's
do
where
that.
you need to scare them a little bit.
Mm-hmm.
They will get scared, honest.
Okay. Thanks for that advice.
It's
Yeah.
okay, don't worry. Um,
It's been really stressful because I'd
I
like my
know it
money
will
back.
be,
They've just
yeah.
been stressing me out.
It doesn't matter if you lose the deposit, at least you can get your other refund back.
Yeah, that's what I want. Yep.
So write to them. Also, do be a bit threatening as well. It doesn't. It just they just get scared if you know a little bit about it.
Mm-hmm.
The next one is wrongful termination, and this is where a contract occurs when a party terminates agreement without a valid legal basis, such as a breach of contract or contractual right to terminate. This can lead to
Mm-hmm.
terminating party being liable for damages to the other party, potentially including loss of profits or other losses resulting from termination. Remedies for breach of contract. The primary main remedy is damages that are money paid to another party, and injunctions may be available also in regards to that. So, an injunction could be where they would have to comply with something and is an equitable remedy.
Yeah.
Termination by frustration. So,
Yeah.
discharge by frustration occurs when an unforeseen event makes contractual obligations impossible to perform or radically alters the purpose of the contract, leading to its termination. This happens when the event is not the fault of either party and neither party could reasonably foresee it. So, this could apply where if there's subject of destruction, for example, if this might apply to you as well, discharge by frustration,
Yeah.
where occurs when an unforeseen event makes contractual obligations impossible to perform or radically
Yeah.
alters the purpose of the contract. This happens when the event is not the fault of either party and neither party could unforesee it. So it could be, in some cases, it could be the personal incapacity due to an illness or injury,
Yes.
which affects the performance. So that could apply to you. Frustration, termination by frustration
Yeah.
because it could apply to people who have got an illness or which affects the ability to perform that service.
Yes.
So maybe something to look at in there. Case is the National Carriers and Penelope 1981. Example situations may occur. The subject of a contract has been destroyed. So if something's been destroyed, struggling, it could be an elements of a party to the contract dies, or a contract has become illegal, or the commercial purpose of the contract has failed. Frustration will not apply to a discharge of a contract. So frustration as means of discharge is a contract is a high legal threshold. It will not apply because a contract becomes more difficult or expensive to perform. Frustration only applies when an unforeseen event fundamentally changes the nature of the contract, making it impossible or radically different to fulfill. Terms of a contract. So again, terms of a contract which are widely used. Contract terms are provisions in the contract that outline the rights and obligations of each party, and they define each party agrees to do the consequences, and the terms are expressly or impliedly put in by law or custom. Coronavirus and termination. So, the coronavirus made it hard for considered, it made it difficult to consider termination of contracts. And, it made it hard for people in regards to manufacturing to make it hard to identify any sort of contracts of payments and demonstrate. So it was sufficient for termination in that instance. 4.2, examine the differences between breach of conditions, warranties, and inanimate terms. Just 1 minute.
Yeah.
So examine in contract law, conditions are warranties, inanimate terms are the consequences of a breach of a contract. Conditions are fundamental terms that allow the innocent party to terminate the contract, warranties being less crucial, and then inanimate terms is the middle ground.
Yes.
Which we've gone through Poussard and Spears case, warranties Bettany and Guy, and inanimate terms in regards to the Hong Kong Fire and Kwaski case. Have a look at these cases, the Squalor and Witchman tools, Lombard, North Central, and Butterworth 1987. And then 4.3, examine the doctrine of frustration. So the doctrine of frustration in contract law essentially provides a legal mechanism to discharge parties from their contractual obligations when an unforeseen event makes performance impossible, illegal, or radically different from what it was originally intended. This doctrine acts as an exception to the general rule that parties are bound by their contractual agreement. The test for frustration. So the test for frustration in contract law centers on whether a supervening event has performance of the contract impossible or radically different from what it was originally agreed. This test involves assessing if the event was unforeseen and not the fault of either party. The case in regards to that is the case of the Davis Contractors Limited and Farham in regards to the element of the test for frustration. Key features in the doctrine of frustration is to discharge the contract. The event causing the frustration must be unforeseen at the time the contract was made. It should not have been reasonably anticipated by the parties. Also, the radical change in circumstances. It could be the impossibility of performance, automatic discharge, limited application. So these are elements of doctrine of key features of frustration. Legal effects of frustration. So frustration in English law automatically terminates the agreement when an unforeseen event makes it performance impossible, illegal, or radically different from what originally was intended. Then we've got the element of practical illustrations. So frustration can be illustrated through various situations where individuals face obstacles or unmet exceptions. So the following is non-exhaustive list of such events such as destruction or unavailability of subject matter, death, illness, or incapacity of a person, resolution or supervening incapacity or cooperation, frustration, supervening outbreak of the war, delay sufficient long to frustrate the parties, a method of impossible or radically fundamental difference. So this is, I think, the references for that. Contract law, learning outcome 2. The next learning outcome, can you see that on now? Is learning outcome 5, the final one?
Yes.
Can you see that? Understand the remedies for available for breach of a contract.
Contract.
So there
Yeah.
are common remedies available include things like monetary damages, specific performance, and rescission. And they have unliquidated and liquidated clauses, a form of compensation, which is determined by the court, and liquidated damages is determined by the parties themselves. So 5.1, distinguish between liquidated and unliquidated damages. So liquidated damages are pre-agreed and specified in a contract to anticipate for anticipated loss of breach, while unliquidated damages are not predetermined and must be assessed by the court or the arbitrator. Unliquidated damages. So unliquidated damages are the amount of damages is not specified in the contract. Sorry, is that liquidated, unliquidated damages? Yeah, so if a breach occurs, the court or an arbitrator will determine the amount of damages based on the actual losses, and the party claim unliquidated damages must prove the actual loss they have suffered as a result of the breach. And then we've got discharge of contracts, so discharge by agreement, discharge by performance, discharge by contract by frustration, and discharge of contract by breach, which we looked at earlier in more detail as well. Remedies for breach, you've got damages, which is monetary compensation, quantum merit, which is as much as he has earned, specific performance, courts require this, injunction, repudiation, and restitution. Supply and of goods and supply of services regulates contracts for the transfer of goods. And Consumer Rights Act 2015 applies to all consumers for goods and services, and where the does not apply to contract for sales of goods made between businesses. What is a contract for the sale of goods and services? So a contract for the sale of goods or services is a legally binding agreement where a seller transfers or agrees to transfer ownership of goods to a buyer in exchange for a price. Implied terms in sale of goods. This is implied terms in the contracts for the sale of goods are unwritten, but legally binding obligations that are assumed to be part of the agreement, even if not explicitly stated.
Yeah. Okay.
So they're saying that the goods should be fit for purpose, they should be of satisfactory quality. These are the terms that would be mentioned in that. Remedies under the Consumer Rights Act 2015 are things like it Key remedies are repair, replace, or refund. So each remedies are in the Act under conditions under the Consumer Act. 5.2, assess the aim of damages in contract law. The primary aim of damages in contract law is compensatory. So courts award damages to place the injured party in the same position they would have been had the contract been performed as agreed, not to punish the breaching party. There has to be a causational link between the parties, and that's the but-for test, particularly in breach of contract and tort cases. And what the question is would the claimant have suffered the damage? Measure of damages. So how this would apply in contract law would it refers to the legal principles used to calculate the amount of compensation owed to a party who has suffered loss due to the breach of a contract. Essentially, it's about determining the financial equivalent of harm caused, aiming to put the injured party in the position they would have been in had the breach not occurred. And that's in the case of Robinson and Harmon 1848 and the case of Anglia TV and Reed 1972. Remoteness of loss. And this would occur if refers to the principle that limits the type of damages recoverable for a breach of contract to those were reasonable foreseeable at the time the contract was made. So essentially, it determines which losses are too distant or indirect to be considered a consequence of breach and therefore compensatable. And that's the case of Hadley and Baxendale again, 1854. The next slide looks at the element of remoteness of damages, and this damage must not be too remote that it must have been reasonable, foreseeable, and it is objective test. And the case is the eggshell principle they use in the overseas tankship case and the intervening acts, which is Northus actus intervenus. Mitigation. Mitigation of loss or the duty to mitigate requires a party who has suffered a loss due to a breach of contract to take reasonable steps to minimize the loss. So defenses in negligence, which is the next slide, is contributory negligence by the claimant, consent, illegality. So in negligence, the defendant can raise several defenses to avoid or reduce liability. These include, as we mentioned, contributory negligence, where the claimant's own actions contributed to the negligence. Violento non fit injuria, which is the consent, where the claimant voluntarily assumed the risk. Illegality, where the claimant has injured the injured while engaged in the activity. So they would have to look at each case individually because all cases are not the same. 5.3, compare and contrast the different measures used for addressing damages. Different measures of damages exist depending on whether the claim is based in contract. In contract, the primary aim is to compensate for the loss of bargain, putting the injured party in the position they would have been if the contract had been fulfilled. This is often assessing the difference between the value of promised performance and the actual performance. So the expectation damages and the resilience damages. So the expectation damage is the most common one, giving the claimant the benefit of their bargain. Remoteness. The term remoteness we looked at a little bit earlier on, and that refers to the legal test of causation, which is used to determine the type of loss caused by a breach of contract, and a duty may be compensated by the damages awarded. And the case in regards to that, again, the case of Hadley and Baxendale and the transferred shipping case, 2008. In regards to tort law, in relation to some types of tort, the test for remoteness of damage is where the kind of damage suffered was reasonable, foreseeable by the defendant. Famous case is the case of Bank Booksellers Lambert and Eagle Star Insurance Company, 1996. Causation, which is a principle used in the assessment of damages for breach of contract or tort, and losses may be foreseeable at the time of the contract, at the time of the breach, but they can only be recoverable if the losses was caused by the breach of duty. Mitigation. The rule of mitigation requires the claimant to take steps to minimize its loss and avoid taking unreasonable steps that increase its loss. 5D1, which looks at the distinction element, assess the amount of damages that can be claimed for a specific breach of contract. So in assessing damages of breach of contract, the court aims to compensate the non-breaching party for the losses they incurred as a result of the breach, putting them in the same financial position as if the contract had been fulfilled. And this is typically achieved through compensatory damages, which cover direct financial losses and may also include consequential or incidental losses. The most common forms of breach are defective performance, delayed performance, and complete non-performance. Breach of contract claims. So a breach of contract claim arises when one party in a legally binding agreement fails to fulfill its obligation as specified in the contract. To successfully pursue a claim, the claimant must demonstrate the existence of a valid contract and the other party's breach of that contract and resulting in damages. So breach of a contract claims how it works. So breach of a contract claim arises when one party in a legally binding agreement, as we said, fails to fulfill their obligations. To make a claim, the innocent party must prove the existence of a valid contract, the breach of that contract, and the resulting loss of damage. If successful, the court may award damages to compensate the injured party, aiming to put them in that position. So the elements they must look at implied, expressed, and also types of terms of a contract, condition, warranty, and inanimate terms. So these are some of the links that you could look at in regards to getting information on any of them. You just have to right click them and have a look at each one. So you've got consequences of breach of contract, repudiatory breach, anticipatory breach, assessing repudiatory breach, what happens after repudiatory breach, affirmation and repudiatory breach, consequences of affirmation and consequences of termination in contract law. You can also look at alternatives to repudiatory breach, material breach, fundamental breach, substantial breach, and serious breach. And what about any breach of contract? What if there's no termination clause at all, and illegal contracts versus breach of contract? And these are the references which you can right click on the final one, which is learning outcome 5. Okay, so is there any questions? I know it was quite a full-on session on the 5 learning outcomes. Is there any questions before we go into the assignment discussion session? Do you want a break?
I think I'm fine. I'm good.
Are you sure? If you want
Yeah,
a
I'm
break,
fine.
have you got any questions about the learning outcomes before we go into the assignment discussion?
Oh no, I don't have any questions.
Excellent. So we'll go into the assignment discussion, okay? So, right, okay, let me just take that on that side. Right, see if you can. Can you see these slides, which is the assignment discussion?
It's not coming up yet.
Did it come up now?
It's there now.
Okay, so it's really important, which I'll go through a little bit and show you the policies and stuff, do's and don'ts as well. Make sure you read the plagiarism policy as well. That looks at elements of plagiarism in regards
I
to.
did already. I read all those
Excellent,
already. I've
excellent.
started my assignment as well. So
Oh, good. That's really good. The plagiarism policy is really important because you are signing a declaration, which we'll go through a little bit, and make sure you are
right.
following the plagiarism policy and not the use of AI and things like that, because people are doing it too much nowadays. Um,
Wow.
so this is the assignment. So the unit aim is to equip learners with the knowledge of key principles of contract law, such as validity of contract, terms of contract, mitigating elements that affect the validity of contracts, remedies breach, and looked at the commercial and consumer context. So this is the assignment declaration. This is available if you right click on that link at the bottom. This is to say that the work that I've done is your own work. You've read the policy. The work you have done is your own work, and you've not plagiarized it or copied anyone else's work. You've referenced it. You've sourced everything. You've paraphrased things if you had to. You need to make sure you've referenced everything as well, because that's really important. And also that you've not colluded or copied any other person's work, and you've acknowledged that the work is yours. You are signing a declaration. And again, we're teaching contract law. Is this a contract? Lisa, is this a
Pardon me?
contract you're signing?
Yes, it is.
Yes, it is. And it's to declare that the work is your own, that you have not
Mhm.
copied, you haven't bought from any agencies or anything like that. This is really important when it comes to um, looking at your work in regards to plagiarism and collusion, okay?
Mhm.
So the useful tips is read the tasks carefully. Focus on the details, the command verbs. Broadly, just as guidance, I suggest an action plan, for you. Explain, define, describe, compare, use Harvard referencing. And I'm going to reiterate this throughout the assignment. So there might be some repetition. Use Harvard system of referencing. Do you know how to use Harvard referencing system?
Yes, I just used it with my criminal law assignment, which I passed.
Yeah, and you could use something called Neil's Toolbox that would help you as well. That's really good. I'll show you that at the end, okay?
Okay.
Stick to your word limit as it's specified, okay?
Mhm.
Again, plagiarism and collusion is when you submit your work, it's really important, that because you are presenting someone else's ideas, you need to make sure you're referencing everything. Collusion is, someone else's work that you are plagiarizing. So it's taken very seriously, and, you must refer to the academic misconduct policy, which is on Moodle. So at the start of the assignment, you need to have a table of contents. You need to make sure your assignment is font size 12, 1.5 spacing, page numbers to be inserted. Make sure you have a brief introduction, very brief, and make sure you put the assessment criteria in the headings.
Right.
This is some general information about the course. It's taught on the VLE, which is Moodle. That's the one you need to
Mhm.
be referring to. That's the one you need to be getting all your information from, any additional reading, any ebooks, any sort of issues you have. Moodle will be the main thing that you would go on. The assessment, there are different tasks in this assignment. The unit grading is a pass, merit, and distinction. You need to, when you submit your assignment, you need to put in an email what you expect to get, what you want to get. If you want to get a pass, you need to identify you want to get a pass. If you want to get a merit, you want to identify you want to get a merit or distinction. Okay. When you are aiming for each of them grades, for a pass, you need to complete all the pass criteria. For a merit, you need to complete the pass and the merit criteria. For a distinction, you need to complete the pass, merit, and distinction. Do you understand? You don't
Yes.
just complete the pass to get a distinction. Okay, you need to complete, if you want to get a distinction, you need to complete all the pass criteria, the merit criteria, and distinction criteria.
Mhm.
So the assessment is you would get a pass for the unit. You need to be, all the learning outcomes need to be met from learning outcome 1 to 5. And it's an assignment must be in Word document, and it's 3,500 words. Okay, it must be one document of Word. It must not be so many documents. Okay, so do your assignment in one document.
Yes.
Study skills, the skills developed through the assignment are things like critical thinking. You need to think critically and look at what the question is asking you. Plan and organize, gather information, note taking and summarizing, analysis, written skills, academic skills, including referencing, application of IT skills. Assignment scenario. So here is where the core of it starts, okay? So you are a trainee solicitor in BLLLP. Your supervisor has asked you to advise on a number of contractual matters relating to one of the firm's clients, Mr. Wilson. Okay?
Mhm.
So you have to give advice on Mr. Wilson. So the first one is sale of paintings last year. Mr. Wilson inherited two paintings from his uncle. He does not particularly like the paintings and on Monday places the following advert in a local newspaper. For sale, 2 paintings, circa 1950s, price negotiable. Okay, so let's go on the next one. The advert, okay? The advert contains a photograph of each painting and Mr. Wilson's email address. Mavis sees the advert on Tuesday. She thinks that the paintings are by the famous artist Dale Salvadori and immediately sends an email to Mr. Wilson saying that she will pay £200 for both of them. Wilson emails back on Wednesday morning saying that he will accept the £200 per painting and the Mavis should communicate her decision to him no later than Friday morning. On Wednesday evening, Wilson receives the email from Polly. It states Polly will pay £500 for both paintings. Wilson then responds to Polly's email straight away saying it's a deal. They are yours. On Wednesday evening, he also sends an email to Mavis informing her that the paintings are no longer for sale. Mavis' email account is hacked on Wednesday morning and she cannot send an email or receive any emails. She sends a letter to Wilson on Thursday morning saying that she's happy to pay £400 for both paintings. The letter is received by Wilson on Saturday morning. By this time, Wilson has discovered that the paintings are by Dale Salvadori and refuses to sell them. Both Mavis and Polly each claim that they have a valid contract with Mr. Wilson for the sale of the paintings. So, the first task is you need to produce written advice on each issue for your supervisor to consider in the case of A. Mavis versus Wilson and B. Polly versus Wilson using the information provided. You must ensure that you distinguish. So that's your first part of it, okay? Distinguish between an offer and invitation to treat, which that's on learning outcome 1, yes? Yeah, so you need to look at learning outcome 1 for that one, and you need to look at learning outcome 1 in regards to distinguishing between an offer and acceptance and invitation to treat. Okay, the second, so would you put that as a heading? How
For
would
my
you
task,
do that? How would you do that for the first part?
you're talking
What
about
would
for
you do?
my task?
What would you do? Would you first talk about A, Mavis and Wilson, yeah?
Mm-hmm.
And then B about Polly and Wilson? Would you look, what would you need to do? So here you would need to distinguish between an offer and an invitation to treat. You would need to use case law, okay? You would need to
Yes.
use cases here, such as the case of Partridge and Crintington. You would
Mm-hmm.
also need to look at cases in regards to invitation to treat and offer and acceptance.
Right.
So for offer. And then the second part is you need to identify and explain the legal rules applicable to acceptance of an offer. And here you would look at the postal rule, you would look at communication methods, and for both scenarios, okay? Whether it was an email, whether it was a written consent, you would need to look at them. And you would look at cases as such as Hyde and Wrench, Taurus and Miles, Thomas and BPP, and you would look at whether there was a binding contract for Mavis or for Polly. Okay?
Mm-hmm.
Is that okay for that one? Do you
Yes.
understand that?
Yes, I understand it.
Excellent. Then the second part, which is this is A. So Green Cottage. So Wilson wants to open a boutique hotel. He buys Green Cottage for £300,000 and on 1st of February hires a construction company called Build It Perfect, BIP, to carry out refurbishment. Under the agreement, BIP needs to complete the work by the 1st of May for a fixed price of £50,000. On 1st of May, BIP informs Wilson that they are experiencing financial difficulties, that unless he pays them an extra £20,000, they will not complete the work by the agreed date. Wilson
Mhm.
is furious. If the work is not completed by 1st of July, he will need to postpone the opening of the hotel and cancel the bookings. Therefore, he reluctantly agrees to pay BIP the additional 20,000. BIP completes the work by 1st of July. So, in regards to this, you must continue to provide written evidence in the case of Wilson and BIP for your supervisor to consider. In your written advice for Wilson and BIP, you will be looking at the information provided. You must ensure that you firstly look at assessing the requirements for valid consideration. So here you would be looking at, for this task, consideration and duress. So you would look at discussing what consideration is. Would you need to look at what valid consideration is as well?
Yes.
Yes, you would need to look at cases such as Hartley and Ponsonby, Stilk and Myrick. Then you would look at the next one, which was analyze the development and doctrine of duress, AC 3.3. Here you would need to look at what duress is, economic duress, and whether BIP's demand for more money was lawful or not. And for then that would be for the pass criteria. Okay, so do you understand that? Lisa, do you understand what you would need to do for this task? Hello, can you hear me, Lisa? You gone off? Lisa? So your supervisor is pleased with your work today and set up a meeting with you to discuss certain points of law. You know that you must be prepared for this meeting, as the supervisor will have high expectations of the discussion. Lisa, are you still on? Lisa, are you still on? Oh, is Lisa, can you hear me? Hello? Lisa? Let's just put it in the chat. See if can you read your chat? Can you hear me? Lisa, can you hear me? Hi, can you hear me now?
Yes, I can hear you.
Excellent. I couldn't hear you, Lisa.
Yeah, because my computer shut down. It went dead.
Oh,
Oh my God.
it had too much of us today.
Just...
So could you
Wow.
understand what you have to do for that task for the pass criteria?
Yes, I do.
Yeah, okay. So then when we go on to the next one, that's for the merit criteria. Here you
Mhm.
need to critique the significance of practical benefit as consideration, and that's looking at AC1M1. And here you will look at the practical benefit, and you would look at the element of William and Ruffy's case. Okay,
Yeah.
that's to
I'm
gain
just
a
I'm just
merit.
trying to pass. I'm not trying to do all that.
Okay, and that's for the distinction. You would assess the limitations of Ruffy and Brothers in relation to the promise. Okay,
Right.
that's for distinction. But if you're saying you're just trying to pass, then we'll get you through that. Okay, so
Yeah.
2B, Wilson orders £30,000 for some new made to measure furniture for the boutique hotel from Dakia. Dakia is to deliver the furniture on 1st of July. Dakia delivers the furniture on schedule, but none of it is of agreed dimensions. Wilson sends it back and wants Dakia to refund him the £30,000 he paid for it. Dakia refuses to refund him, bringing to his attention the following clause contained on the last page of their contract, which was duly signed by Wilson. So, clause 47, no refund under any circumstances. Wilson now finds a local company that can deliver furniture in time for the opening, but it only has sufficient furniture in stock to furnish 3 of the 6 bedrooms. Wilson decides to go ahead with the opening despite the fact that only 3 of the rooms can be hired out. For this task, your supervisor now wishes for you to draft a written advice to Wilson and Dakia for him to consider in the communication you need. So for the first one, you need to explain the difference between terms and representation, which is AC 2.1, and look at the Sale of Goods Act as well. That you put that as a heading and then write the answer under it. You need to identify the sources of contractual agreements, contractual terms, AC 2.2. You need to distinguish third between conditions, warranties, and inanimate terms, 2.3. You need to examine the difference between breach of conditions, breach of warranties, and inanimate terms. And then you need to, that's 4.2. You need to also distinguish between liquidated and unliquidated damages. That's AC 5.1. And then for this, you need to aim the damages in contract law, AC 5.2. And then you would need to compare and contrast the measures used for assessing damages, which is AC 5.3. Now, do not change the wording of this. There's 7 parts to it. Make sure you write each one as a heading and highlight it and underline it and then write the answers underneath that. And it tells you where it is. That would be learning outcome 2, learning outcome 4, learning outcome 5. It tells you where to find the answers, okay? Are you okay with that one?
Yes, I'm fine. Yeah.
Excellent. In order to get a distinction, you'd have to look at these. You'd need to analyze the court's approach to the interpretation and validity of exemption clauses, and you'd need to assess the amount of damages that can be claimed, which is AC 5D1. Then we carry on. C, a day before the opening, he receives a booking request from Robert Milford for a 2-night stay, all-inclusive stay. When Robert arrives at the hotel, Wilson is convinced that he is the famous football player Ronald Massino using an alliance. At reception, Wilson has displayed a few antique items for sale. On checking out, Robert selects a vase from the display and asks whether Wilson is willing to take a check for it. Wilson says that although usually he does not take checks, as he is a famous football star, he will accept a check. To this, Robert smiles and gives Wilson a check for £500. Wilson accepts the check and gives the vase to Robert. When he goes to the bank to cash the check, he is informed that the check is a forgery. Wilson manages to trace the vase to Cam, who had paid £700 for it, and refuses to give it to Wilson. The task for this is that in the written advice to Wilson and Cam, using the information provided, you must first identify the elements of actionable representation, which is 3.1 you would need to look at. And that would be looking at the elements of actionable representation and the effects of misrepresentation. Secondly, you need to differentiate between fraudulent misrepresentation and negligent and innocent, which is AC 3.2. Okay, you'd have to have a look at that and how it was committed by Robert as well. You'd need to bring the scenario into it. In order to achieve a merit, you must examine the remedies available for fraudulent, negligent, and innocent misrepresentation, which is 3M1, and then also to contrast the effects of misrepresentation and mistake on a contract with which is AC3M2, to compare this with contract's validity. Okay, do you understand that?
Yes.
Excellent. 2 days before the hotel opens, Sandra has contacted by Mr. Wilson and contracted by Mr. Wilson, sorry, to sing at the opening night. Opening night phones to say that she will not be performing because she has broken her leg and cannot travel. Wilson demands that Sandra returns the 2,000 he paid her for her performance. In a written advice for Wilson and Sandra, you must explain the different ways in which a contract can come to an end, which is AC 4.1, and that is looking at ending a contract and frustration. Then you would need to look at examining the doctrine of frustration, which is 4.3, AC 4.3. So you need to use case law and bring in Sandra's issue around that as well. So you need to look at the law of frustration. You okay on that?
Yes.
So here also, that's the final one, isn't it? Yes. Is that the final one on your assignment as well?
Yes, it is.
Yes, that's the final one. Make sure you use clear legal reasoning supported by case law and legislation, and make sure you are advising the parties as what you are being asked. Use headings, avoid using bullet points, write professionally, and aim to meet the criteria for a pass. If you want to get a merit and distinction, then you must do that criteria as well. Okay, so
Yes.
for the pass, you need to look at the criteria of establishing all the pass criteria. Sure, you're able to support everything and do extra reading. Use your Harvard referencing and fully use your case law as well and fully cite them. You have 2 weeks from the assignment discussion date to submit your coursework. Use the indicative content to help and guide you structure the assignment. And it must be a professional piece of work, so it needs to flow. And the assignment must be submitted to learnerwork at ukvarsity.co.uk. Some assignment guidance and support. Make sure you start with a brief introduction and end with a brief conclusion. Make sure you're using Harvard referencing for all your work, and you may be able to use Neil's toolbox to help you with the referencing. Make sure you're using diagrams and they're referenced if you are using diagrams. Make sure you have a bibliography reference list and make sure it's in alphabetical order. And if you're using examples, make sure you use examples to identify concepts. Make sure that each part of your work that you're answering, that you have a heading for it, okay? And you need to be referring to the indicative content. Again, give proper headings and subheadings. Make your document look presentable and professional. Number your figures and tables. Following the assignment presentation as against the assignment brief. Ensure at least 12 to 15 references. Keep references should be be in Harvard referencing. I think your word count is 3,500. Is that right?
Yes, it says 3,500.
Yeah. And make sure you also within minus 20% of tolerance for AI. And it is a pass, it's not a pass or fail, it's pass merit or distinction. So depending on what you want to get, it's up to you. Okay. And make sure your tolerance is under, that's so important that it's under 20%, your AI if you're using it. Avoid using it. Document
Right.
structure formatting. Good practice to put your name on the top, your unit number, contents page, start with an introduction, write out the learning outcome if they're mentioning it, font size 12, table of contents, conclusion, and as I mentioned, referencing. Again, read the task carefully, focus on the command words, do not change what you are being asked. So if you are being asked to distinguish between an offer acceptance, offer and invitation to treat, do not change that. Put it down as a heading as that. Harvard referencing, proper headings, make sure your document looks presentable. Again, word count and plagiarism needs to be under 20% minus. Make sure you're not copying and pasting work, and make sure you've read the policy for plagiarism. Make sure you reference all your sources. Make sure a big thing is check your grammar and spelling, because a lot of people don't tend to use the American style. So, for example, for organization, they use the Z instead of the UK English command verbs, S. Refer to ebooks and journals on Moodle, any additional sources you can use. If using UK Varsity slides, then the reference will be as MDT 2022 in the main text, and then in the bibliography you would put multidisciplinary teams, learning outcome 1, slide number 2 to 10, UK Varsity, published on 15th of January 2023. Any questions or queries, or email learnerwork@ukvarsity.co.uk. Submission of your assignment is to be done on learnerwork@ukvarsity.co.uk, and you have 2 weeks of submission of completion of this unit. Okay, do you have any questions?
Not at this time, no. I
Are you
think I'm good.
sure?
Yeah.
Are you okay with your Harvard referencing, or do you want me to show you Neil's toolbox?
You can show me Neil's toolbox, it's fine.
I'll show you Neil's toolbox. It's really interesting, is Neil's toolbox. I'll show you that. Neil's toolbox. A lot of my students at the university use this because it helps them, and they've used it throughout. You know, they've not stopped using it for their work for a long time now. So let's just go back onto Neil's toolbox. Excellent. So can you see this? It says Neil's toolbox. Can you see that now?
Yes.
There's Neil dressed up in his little builder's gear. So type of referencing. So if you want to reference, let's just say we want to reference a book, okay? You would click on that. You can reference a chapter of a book, an ebook, email, anything you can reference. So let's click on referencing a book. Let's put the book title there. Can you see that? So let's put contract law. We put the author, I'll just make one up, Brown, which is the surname, and J. The publisher, Peacock. And then the place of publish, London. Year of publication can be 2023. And it could be whatever edition it is, 1st, 2nd, 13th. Okay, so then you would put all that details in. You can see that, yeah, Lisa? Yeah. Then you press this thing here. It says generate reference. It's made it for you. Can you see that?
Yes.
So you would just copy and paste that into your Word document at the end in your bibliography. It's put the dots, it's put the commas, it's put everything in the right order. You can do that if you want to do a newspaper article, a book, chapter, website, email. You could do it for everything. You just have to put the details they ask you, and then copy and paste that into Word document.
Yes.
Okay, so this you could use for all your assignments. It doesn't mean you just have to use it for this assignment. Any other assignment, anything you do, you would be using Harvard referencing for that for UK Varsity. Let me just show you how to do a website. So if you've got a website, your organization can be, let's just put Red Cross, okay? An example. Article can be contract law. Then the website name can be head row. Just an example. Published 2023. And then year of publication, that's updated. We could have a 2024. And then the full URL. So we can just copy that one, copy. And then paste that into then. And it would generate it. And it would come up. Can you see that? It's done it for you. You just copy and paste that. It's actually made it for you. It's told you you've accessed it today. It's told you where you've got it from. It's actually done it all for you. You just copy and paste that. Make sure everything is in alphabetical order as well. Okay, make sure you are using Word to do your assignment, not Google. Make sure you put in all your work on Word. Make sure you check the grammar. Make sure you check spelling. Make sure you avoid using bullet points, and make sure you are sticking to what you are being asked in the tasks. Okay, so the tasks at the top, you know, make sure you are answering what you want. If you're doing all the past ones, make sure you are answering the past ones and not doing the merit ones, depending on what you want to do. So that one is all the past ones. Make sure you are answering them with reference to the scenario and the cases as well, okay? Have
Right.
you got any questions, Lisa, before we finish the session?
No, I have no questions. You've been great. Thank you so much.
Oh, thank you, Lisa. You've been lovely, and it's 10 o'clock here now, so I
Okay.
it's time for my
Yeah.
bed.
Yes. Thank you so much for your
It's
time.
okay. It's all right. It was lovely teaching you, and good luck with the assignment. If you have any questions, please email learnerwork@ukvarsity.co.uk. Okay, and good
Thank
luck
you,
with
will
getting.
do.
Make sure you're referencing everything properly. Make sure you're using case law, and make sure you are referring to the people in the scenario as well. Okay.
Sure. Thank you.
Thank you, and it was
Thank you.
lovely
Bye.
teaching you. Take care.
Thank you. Have a good night.
Thank you. Bye.
Bye.